One of the messages that I've always maintained across the ICO is there's no point in reinventing the wheel if someone is already doing something similar, when you can sort of obviously chat to them and learn from, what's going right and what's not quite gone so well. So yeah, I think events like this are really useful. I've been at the Information Commissioner's Office for just over 5 years now and worked across quite a range of departments and mainly focused on the public sector side of things. So our team at the moment, I work on the policy and engagement team. So we're very much focused on that kind of going out and speaking to organisations, focusing on that sort of, I guess, more proactive side and trying to get those key messages across. And I think that's very much the kind of way we want to continue our role in terms of how best we can engage with as many people across the sector as possible. So local government is one of our big areas. Our team also deals with the health sector and also education. So, 3 quite large sectors across quite a small team, and that's quite a lot of work that we have to cover. But hopefully I'll update you in a little bit in terms of some of the stuff that we've been getting up to at the ICO. So today, I guess it's this sort of educational side that I wanted to focus on really, just trying to get across some of the key messages, some sort of myths that have been circulating around, and then, like I say, providing a little bit of a guidance update just to let you know, what we've been doing and what we've been busy doing back at the office and sort of pushing out on our website. So in terms of the data protection reform, hopefully most people are aware now that in addition to the GDPR, the General Data Protection Regulation, we've also got the Data Protection Bill, which details a number of national sort of implementing measures from the GDPR. But it's also just worth pointing out that it's not just solely focused on the GDPR, it also sort of refers to a couple of other things. So it will also bring in the Law Enforcement Directive into our UK law. There's also a section that relates to national security, which is outside of the scope of the general EU law. And then there's a section that also covers some additional ICO duties and powers. Obviously, for most of you, it's going to be the sort of GDPR sections in there that are going to be the main focus. And I think really the point that I wanted to emphasise with that is that the bill and GDPR are not exclusive from each other. So together, they're what is going to establish our new law reform within the United Kingdom, so essentially replacing the existing Data Protection Act. And so it's essential that both of them are read together and in conjunction with each other, just so as an organisation you get a full picture of the rights and obligations that are set out across both of them. So GDPR will be implemented on the 25th of May. That seems to be rapidly coming closer. I still can't get used to it. I still keep saying it's going to be implemented next year. I'm not in 2018. And yeah, it's still in draft at the moment. I think the government are working as quick as they can to obviously try and get it published. And I think if everything goes to plan, I think they're hoping to have it sort of finalised by end of March, sort of beginning of April time, all being well. The draft, however, is published on the parliamentary website, so you can still obviously view that. It's just obviously subject to some minor tweaks and amendments before it gets finalised. And I think, as with any update in legislation, change is going to be inevitable. I mean, obviously, we've had the Data Protection Act for 20 years now, and given the developments, the use of data and developments in technology, I think we are long overdue a reform around data protection. And I think it's just really important for organisations to remember that, it's not a total overhaul. We're not starting right back from the very beginning. Its pure aim is to modernise the law rather than, start from scratch and make everyone start from the beginning again. And I think Elizabeth Denham's made this point quite a few times that, it's an evolution rather than a revolution. That basically just looks to enhance and strengthen the current framework that we've got in place. So, in terms of a few key messages, I'd need a full week probably to go through some of the sort of fine intricacies of the GDPR and the bill. So instead, given the sort of 25-minute time slot I've just tried to pull out some of those key messages just to highlight. So the first thing that I wanted to highlight, I guess, is that there's a lot of focus around the 25th of May. And obviously it is important because it is the day that the law does change. But it's just to point out that that day is not the be-all and end-all. You don't get to the 25th of May and, everything stops. I think the GDPR journey started way before the 25th of May. I know this has been on our horizon for a good few years now. I feel like I've been living, breathing GDPR for, I can't remember when it wasn't. So it's going to continue well past the 25th of May as well. And I think especially from the perspective that even with a new law coming into play in a few months, there's still case law being developed under Data Protection Act. And it's just going to be an evolving process. And I think it's just bearing in mind that, it's about evolving and preparing yourselves for the future and putting those key building blocks in place. And yeah, I think a lot of the time the main learning with stuff like this is just in the doing. So people are wanting, some of the really finer points, but I honestly don't think we're going to have them until, past the 25th of May, until we actually start doing this and actually start learning from that. So just moving on in terms of a quick thing that I wanted to point out around data protection officers. Hopefully most people are now aware that the draft bill sets out a public authority as it's defined in the Freedom of Information Act. And I just wanted to reiterate that each individual organisation, particularly from a public authority point of view, doesn't have to have its own individual DPO. So the GDPR does say that one single data protection officer can be appointed across several different authorities and bodies. And I think there's been a lot of panic across smaller organisations from a resource point of view in trying to meet this obligation. And I think that's just a really important point to bear in mind, that, get talking across different authorities, see what other people are doing and see how you can share that kind of resource amongst more than one of you. Moving on to another quick point that I wanted to make around the legal bases for processing. So under the new law, under the GDPR, you still will need to identify a valid legal basis for processing. The legal bases are very much largely the same. There's a few tweaks to them, but a lot of them do kind of transfer over. And our key message, as it always has been with the legal bases, is that it doesn't have to be consent, and that's still very much the case. I've seen quite a few articles recently and even a few pieces of guidance that have been published saying that you will be required to have consent to process personal data, and that isn't accurate. So you are required to have a legal basis, and one of those legal bases is consent, but it doesn't always have to be consent. And I think that's a really important point to make, because choosing to rely on consent where there's potentially a more appropriate legal basis to rely on, you could be making things a bit more difficult for yourself, really, because you're going to have to take into consideration, is that consent valid? Is it freely given? Is there an imbalance of power there? Does that individual feel like they're obliged to give that consent because they're frightened that they're not going to get a service in return? And also, what happens if that individual withdraws their consent? So all of those things you've got to take into consideration. And our draft guidance around the issue of consent does say that most public authorities in delivering their kind of functions and powers should be able to rely on the public task condition under Article 6(1)(e). And a lot of guidance, I think, is being a lot more explicit around that point. It may not always be the case. It's still a case-by-case basis, and you should still look to make sure that it's more appropriate. But in a lot of the circumstances, it probably will be more appropriate than consent. And then sort of linked into that is, while you don't have to always ask people if you can use their data, you are required to tell them what you're doing with it, which falls under the transparency requirement. And again, this is still very much there and very much emphasised within the GDPR. It's introduced an individual right to be informed, and it just requires that it's essentially the public trust element, being as open and honest with people as you can about what you're doing with that information. And within that is also letting them know what legal basis you're relying on to process that information. So again, it's just really clear that you're obviously clear on your purposes that you're processing it for, and that you can communicate that to individuals in a transparent manner. And just around that, we have already updated our privacy notices code of practice. So for anyone that's wanting a bit of guidance around their fair processing notices, we have already updated that, and it's likely that we will be doing that again in the future. And then just another quick one around the legal basis. So like I just mentioned, our guidance highlights that the most appropriate lawful basis for public authority is going to be this public task official authority one under 6(1)(e). And it's pretty self-explanatory, really. It essentially covers the process of information to perform your functions or exercise your discretionary powers as a public authority. And it also covers processing to perform a specific task in the public interest. So it's twofold, that one. So it is quite a broad reaching condition to use. And just to highlight that we are just finalising our guidance on the public task condition, and that's expected around the end of January, so hopefully in the next sort of week or two. And then just on the flip side of that, in terms of legitimate interests, I think a lot of public authorities currently rely on this condition. And under the new legislation, if the purposes that you're relying on this for is for performing your public task or function, you're no longer going to be able to rely on this condition as a legal basis, and the GDPR is explicit on that. However, if the purpose falls outside of your public task or function, then you can still rely on that legitimate interest. And if it's within your public task and function, why would you want to rely on legitimate interest when you've got 6(1)(e) there as an adequate condition to rely on anyway? So it's just to highlight that kind of tweak. And if you are looking to rely on on legitimate interest, there is a 3-part test to consider. And again, we sort of detail all of this in the guidance that we've just produced on legitimate interests on our website. So a final quick point that I just wanted to make around enforcement before I finish up on guidance is one of the points that stands out within the GDPR is the increased fines that are available to the ICO to issue to organisations. And I think there's been quite a number of scaremongering articles, across recent months saying the ICO are going to come out, they're going to whack massive fines on you, they're going to make early examples of you for getting it wrong, for minor infringements. And again, that's not really 100% accurate. Yes, we have got greater fines available to us there to issue, and I think they are a really useful tool sometimes in using, for example, senior level management, getting them on board with this kind of these kind of changes money obviously talks in those kind of situations. But from my perspective, and coming out talking to organisations who are doing this in practice, I'm not going to stand up here and start trying to scare organisations with these fines. I don't think it's a sort of very good approach to take. Currently, we use our powers where it's justified and necessary and where it's proportionate to do so, and that will continue to be the case under the GDPR. So a lot of the time, if you actually go and look at the kind of cases where we issue fines, it's where organisations have repeatedly got it wrong, where we've provided advice, and where they've perhaps just not bothered to implement that advice. If you can demonstrate that you've got the appropriate thinking in place, the appropriate building blocks there, you've tried to put those processes in place, then you'll find that the ICO is a proportionate and sort of pragmatic regulator. And that's very much, I think, the approach that we'll be looking to continue under GDPR. So in terms of guidance, Article 29 Working Party guidelines are probably what we describe at that kind of high top level, and they've issued guidance already on all of these areas. We've actually been quite heavily involved in this guidance. We've sat across Article 29 and we've fed quite a lot of input into this guidance, so we have made our views known. It's definitely worth having a read of this guidance if you're sort of struggling on any of these issues. And like I say, some of it is quite high level, but there are some really useful points in there and some useful examples. In terms of ICO guidance, the biggest piece that we've got recently is overhauling what was the overview of the GDPR and turning that into the now guide to GDPR. And it's basically just a much more comprehensive guide that we'll be building upon over the next couple of months. And essentially it will become that overarching guide to the GDPR. And I think the layout in it is very similar across each of the subjects. We've tried to include a lot more summaries and a lot more checklists to sum it up at the beginning to make it a lot more digestible and to make it, I guess, easy for organisations to pick up and get the key points that they need to know straight away. So if you're looking for any kind of guidance points, I'd definitely recommend to go there first. And right at the very top of that, there's a What's New section, and that highlights what the latest additions within that, so it's a big PDF, has been. So since we launched the GDPR guide in November, we've now written and added these following sections, and then we've also expanded guidance on those four as well. So it's been quite a busy few months really in terms of trying to get that guidance out there and obviously give organisations the information they need to sort of make these preparations. We've also published some FAQs for small organisations across health, local government and education. And these are available on our sector pages. So on our website, there's a specific tab or a specific point for local government, I think, or local authorities. If you click into that, we sort of, I guess, update all of our key bits that are relevant to those sectors, and you can find the FAQs within there. And then most of those, I think people should probably already aware of now. They've been out for some time. So things such as the 12 steps to prepare for the GDPR. One of the things I would put on there that's quite useful, point out, is the getting ready for the GDPR checklist. I think it's under the heading of the SME toolkit, but it's actually a really useful tool. It doesn't just need to be for SMEs. All organisations can use that, and it's almost like a little sort of toolkit to assess your GDPR readiness, and that's quite handy. The inevitable question, will the ICO be producing sector-specific guidance? We've always been asked this question, and since GDPR we've been asked it even more, and I'm afraid the simple answer is no, not really, for that. It's not obviously for the fact that we don't want to, it's just obviously it's such a massive task when you think about the amount of sectors that we have, and to write, you know, specific guidance for each of those sectors and then manage that and update that guidance. It would be a huge task, and something that we just simply don't have the resource to do. And I think we often find that those working within the sector, working closely to those kind of areas, often provide the better expertise in those areas. And then that combined with our knowledge and experience usually creates a much sort of broader reaching practical piece of guidance. And we found that's a really useful approach that works. So yeah, we're more than happy to feed into guidance that's being produced, but we just won't be producing it ourselves.